Hi, my name is Larry Donahue. I'm with Law for Small Business, and what I'm going to talk about today is nightmare horror stories. I'm an attorney, so I have to protect my clients. All clients have attorney-client confidentiality with us. So I'm going to give you some examples of what could happen if you are renting property. And these can be real-world examples, but I can't go into too many specifics because I do have to protect the attorney-client confidentiality. But I think it's important for you to know, if you're considering renting property, what could happen. First thing I want to mention is everybody thinks about insurance, and you do need to have insurance, of course, landlord insurance for the properties that you rent. The one thing you need to understand, however, is that insurance is not the end-all be-all. There are many times an insurance policy will not cover a potential problem, and the two biggest issues are going to be one, an exclusion on the policy. And I'll give you an example of an exclusion. Flood damage, for instance. You're going to find that in a lot of exclusions. When would you have flood damage? Well, if there's a small fire and the fire department goes and floods the house, or there's pipe damage, or the tenant does something stupid and leaves the water running, that may not be covered as well, for example. The other one is intentional acts, and that's your intentional acts. And what would that mean? Well, I'm going to tell you some stories, and each of the stories are going to have potential problems with the insurance company. And this is why I want you to know about what these issues are, so that when you are moving forward, you would think about really putting an LLC or structure in place to protect you personally from what can happen within your rental properties. So let me describe scenario number one, nightmare scenario number one. It involves an apartment complex, 2-bedroom apartment complex with 2 couples, a couple in each bedroom, and they're all roommates, friends. So we have 2 couples, and apparently what happened is the girlfriend of one of the couples gets together with the guy with the other couple. So they have an affair. The guy whose girlfriend had the affair turns out had a criminal record and murders the guy that his girlfriend had an affair with. So there's a murder in the apartment complex, and the issue was, did the landlord have a responsibility to do a background check? And if he would have done that, he would have found out that one of the tenants had a criminal background and not allowed him to rent the property. And it was a big issue for our client. He had to defend himself against the others and the family of the deceased, and it was a very trying experience for that individual. Nightmare scenario number 2. This involved a standalone unit that was rehabbed. It was taken down to the studs, and the property is surrounded by chain link fence. And contractors would come and go during the evening, come in the mornings, leave in the evenings. And one evening, the contractors closed the gate but didn't lock the gate. And unfortunately, at the time, some neighborhood children had entered the property at that time at night, and one of the children was exposed to or came in contact with exposed wiring and electrical and got severely injured, not killed, thank God, but severely injured with, basically was electrocuted. And what happened was the insurance company declined coverage, calling it an intentional act. Basically, our client did not lock the gate. And it was not our client, it was the contractor that he had hired, but the contractor's duties go towards the owner, and because they're basically an owner's agent. And so it was considered an intentional act leaving the gate unlocked, which allowed the children to enter the premises and become electrocuted, and therefore had to fend off a rather substantial lawsuit from the family of the child. And our client did not have an LLC either, and so had a fight of their lives trying to defend themselves. Nightmare scenario number 3. There was a fourplex rental property apartment, fourplex apartment, and it was situated near the street, and the way the parking lot was and the street was, there was sort of a curve or a bend. Somebody ended up driving right through one of the apartments in the complex, and there was a guest in the unit, not the tenant. The tenant was there but didn't get injured, but there was a guest in that apartment complex when the car drove through it. And so there was a lawsuit against our client, the landlord, claiming that given the way the street was angled in the parking lot, that he had a duty to erect some barriers to prevent something like this from occurring. And so he had to fend off a lawsuit, not from a tenant who he has a contract with, but a third-party guest who he has no relationship with whatsoever. And so something like that is a claim for negligence. And that's a big problem, because in some states you have comparative negligence, where even if the landlord's 1% responsible, then the landlord needs to cough up 1% of whatever the damages were. So it's very hard to avoid some sort of cash payout or liability in those kinds of circumstances. Finally, the fourth nightmare scenario was the fire. And this one's a really interesting one. The property was a standalone home, and a ceiling fan in one of the back bedrooms stopped working. The client found an electrician, sent him in to repair the ceiling fan, and that went off without a hitch. Everything was fine. About a week later, a fire starts in that back bedroom, and the tenant leaves the property, goes to a neighbor, asks the neighbor to call 911, and then goes back into the property for some reason, and then becomes, is overcome by smoke inhalation and dies. So the tenant was killed in the fire. The fire, it appears, was started by the electrical problem with the ceiling fan. And it turns out that the electrician that was sent in there wasn't properly licensed, bonded, or insured, even though he said he was. So the family of the deceased, the family of the tenant, who, by the way, also lived there but was gone for the weekend, claimed that the landlord hired, defective or unlicensed people, and that's why the fire started. So the insurance company declined coverage, and there was a lawsuit filed against our client, who did not have an LLC on the property. But interestingly enough, what the insurance company did do was send in a fire investigator to do the research. So they declined coverage, but they sent in an investigator. The investigator determined it was an unattended candle in the bedroom, not the ceiling fan, that caused the fire. And then, of course, the insurance company then agreed to, step in and defend against the wrongful death claims of the tenant's family. So thank you for watching. I'm not trying to scare you, but I think these are real-world events or circumstances which highlight the need for landlords, property owners, to have an LLC. And our recommendation is an LLC per property, and it's part of your risk mitigation strategy. You should have insurance, you should have an LLC, you should have things set up properly, you should have good contracts, you should have tax situation properly identified for your holdings. It's all of these pieces are part of your puzzle to manage your long-term portfolio and minimize risks. So a limited liability company for each property that you own to help limit risks in the fallout from catastrophic events like the 4 that I had just mentioned. Thank you for watching.